and I give the call to the most honourable member for North Sydney.
Thank you, Deputy Speaker. While I am the first woman to represent the electorate of North Sydney, I'm not the first independent. And like many in my community, I'm proud Ted Mack, the father of the independent movement, once represented us. A renowned advocate for greater transparency and accountability in government, Ted famously offered the following quote: "Government should be open to public scrutiny. Elected representatives should enable people to not only participate in all decisions that affect them, but ultimately find ways to have people make decisions for themselves. The very basis of democracy is that a decision taken by the public as a whole will be right more often than a decision taken by an elite group." It is through this lens, then, that along with members of my community, I've reviewed the Administrative Review Tribunal Bill 2023, the Administrative Review Tribunal Bill 2023 Consequential and Transitional Provisions No. 1 Bill and the Administrative Review Tribunal Bill 2023 Consequential and Transitional Provisions No. 2 Bill. Australia's administrative review system provides protection for individuals from unfair use of public power, and it's essential for public confidence in government. Sadly, the current Administrative Appeals Tribunal, known as the AAT, is plagued by inefficiencies and failures. And after years of abuse, this package of reform provides much-needed opportunity for the government to rebuild public confidence in this process. Theoretically, we should all welcome this reform. It is the result of long-term advocacy from many across our communities. Yet there remains inconsistencies and challenges in the package that, without change, will continue to condemn people seeking redress under the ART for visa or citizenship issues by ensuring they know to be a non-citizen is to be second-class in this country. These issues could be addressed through modest changes in the Administrative Review Tribunal Consequential and Transitional Provisions No. 1 Bill, and these changes would strengthen the overall system by ensuring all people are treated equally under the law. But for this to happen, this government must show they are prepared to do more than pay lip service to the very principles of international human rights law and show courage to lead us to a better place. For over 3 decades now, the mistreatment of refugees and asylum seekers in Australia has tainted our international human rights reputation. Non-citizens, including those seeking asylum, refugees and the stateless, experience structural exclusion and intersecting barriers to accessing justice immediately upon entering Australia. These barriers include the impacts of trauma, language barriers, mental health issues, financial distress and cultural differences. In the pursuit of equality before the law, then, any reform to the administrative review in our country must account for this and ensure all applicants can equally access a fair and just review process. While these bills have the potential to pave the way for a fairer and more efficient operation of Australia's administrative review system, in their current form they do not achieve that outcome. There are positive changes to be welcomed in them. They include the implementation of an independent merit-based process for appointment and reappointment of members, the re-establishment of the Administrative Review Council and the abolishment of the Immigration Assessment Authority and the fast-track process. In particular, the implementation of an independent merits-based process for appointment and reappointment of members is welcomed, as the previous process had become highly politicised, with the governmental politics of the day exerting far too strong an influence on the decisions of those appointed to the AAT. In fact, data from the Kylea Centre Data Lab reveals the policies of the political party in government at the time a tribunal member was first appointed to the AAT had a significant effect on the outcomes of their decision-making in protection visa cases in particular. Ultimately, the new system should encourage applicants who have the relevant knowledge, skills and expertise for such a position to apply with confidence, knowing that any lack of party connections will not be a hindrance to their potential employment. Complementing this reform is the introduction of the Administrative Review Council, and this body would contribute to the independence, transparency and accountability of the new system. If done well, it could play a key role in reviewing complaints about members and in collecting and analysing data on the operation of the tribunal. Further, the abolition of the Immigration Assessment Authority and the fast-track process will see an end to a system that was cruel, inefficient and heavily politicised. Both were established to allow a review of the refugee status determination decisions made under legislation passed to deal with what's known as the legacy caseload of asylum seekers who arrived in Australia as unauthorised maritime arrivals between 2012 and 2013. But both failed in their duty to provide fair and effective review of asylum applications, with little done to expedite or resolve the legacy caseload. In February 2023, over 12,000 cases remain unresolved. In truth, many of the people refused under the fast-track process are indeed refugees, with strong claims for protection, but they have not received a fair, thorough or robust assessment from the IAA. I echo calls then for this government to introduce a policy to ensure those previously refused under the fast-track process receive a fresh review. I also reiterate my calls for Royal Commission into our offshore processing of asylum seekers. At some point, we must turn a light on this long-term government policy, not just to hold those who have been instrumental to the destruction of literally thousands of lives to account, but to also ensure past mistakes are not repeated. Ultimately, while these bills seek to strengthen integrity and improve accessibility to the ART, I hold seriously concerns they fall well short of that goal. The design of this legislation means many of the benefits being introduced broadly will not apply to the Migrant and Refugee Division. Indeed, the Administrative Review Tribunal Bill maintains the carve-out of a separate, more restrictive procedural code for Migration and Refugee Division in the Migration Act of 1958. The decision to retain this code undermines a lot of the good this legislation could do, as it creates a disparity in the treatment of migrant and refugee applicants compared to applicants generally, preventing them from equality under the law. And this just seems incomprehensible when viewed within the self-described ambition of this reform to establish a unified, cohesive tribunal with flexible powers and procedures that best meet the needs of applicants. This tribunal is intended to play a vital role in protecting the rights and interests of members of our community. It will be required to pursue that objective by providing administrative review that is fair and just, resolves applications in a timely manner, is accessible and responsive to the diverse needs of people involved, improves the transparency and quality of government decision-making, and ultimately promotes public trust and confidence in the tribunal. Yet, the carve-out of separate and more restrictive procedural code for migrant applicants contradicts these very principles. The justification for such a carve-out is on the grounds of efficiency. And it is true that the AAT has historically faced major struggle in processing of the backlogs in immigration and refugee applications. But rather than what is currently proposed, these applicants have incredibly high needs that require dedicated measures to improve accessibility, not carve out and hinder them. This differing treatment of some is not reflective of meeting diverse needs, and rather it is discriminatory. As evidenced in the Refugee Advice and Casework Service submission to this bill, migrant and refugee applicants typically experience barriers to accessing justice that others do not. And in this context, the distinction between citizen and non-citizen releases the ART from the obligations to comply with procedural fairness for all. Ultimately, the shortcomings of this separate procedural code can be broken down into three core areas. The first of these is the inconsistency in the time limits for migrant applications. Where this legislation generally allows the ART to extend the period during which an applicant may apply to the tribunal for review of a decision, it provides that this time extension does not apply to reviewable migration or protection decisions. The only other options available to these applicants would be to apply for a judicial review in the federal court or seek an exercise from the minister's non-reviewable, non-compellable discretion, both channels which are currently overwhelmed and come at a significant cost in terms of time and resource. The second shortcoming is the codification of the natural justice hearing rule for migrant and refugee matters, which, when compared to the common law approach of others, does not make sense. In fact, it significantly increases the resources required by the tribunal's members and staff, including additional training. And thirdly, it should be deeply concerning to all of us that this bill retains provisions that restrict the right for migration applicants to be represented. I cannot be clearer when I say the exclusion of legal representation for migration and refugee cases, in contrast to all other cases at the ART, is wrong. People with migrant and refugee applications are often unaware of the legal requirements of their appeal and often need assistance to explain their case to a decision-maker. The lack of support for migrant and protection applicants in accessing legal assistance and representation is not only bound to hinder the success of the case I believe it is morally corrupt. Unhindered access to legal assistance for migrant applicants needs to be brought in line with others generally in the ART. At the same time, there needs to be adequate funding so applicants who cannot afford legal assistance and representation are able to do so. Ultimately, my community joins me in arguing the substandard treatment for migrant and refugee applicants is neither fair nor just, and we must do better. For these reasons, I will be moving a second reading amendment to the Administrative Review Tribunal Consequential and Transitional Provisions Bill No. 23 when it is brought forward at the end of this cognated debate.
Thank you. And the debate is interrupted in accordance with Standing Order 43. The debate may be resumed at a later hour, and the member will be granted leave to continue if necessary when the debate is resumed.
The question is that this bill be now read a second time. I give the call to the honourable member for North Sydney.
Thank you, Mr Speaker. The amendment, as I was saying, the amendment I will move at that time calls on the government to ensure all applicants can equally access a fair and just review. For this to be possible, it accordingly calls on the government to remove the separate set of procedures under the Migration Act 1958 from the bill so that procedures that apply to applicants generally also apply to migrant and refugee applicants. In the words of the North Sydney constituent and long-term human rights advocate Professor Mary Crock, where it is separate for migration applicants, the code is always more punitive and restrictive than the general ART provisions. It is very disappointing that migrants should continue to be treated as persons with inferior procedural entitlements, specifically at a time when almost 1 in 2 Australians are either born overseas or have an overseas-born parent. We should stop seeing migrants as less worthy of procedural entitlements just because they are non-citizens. This is most especially the case where applications can involve matters of life and death or profound disruptions to human rights, including the right to live with a partner and immediate family. Mr Speaker, as the representative of a richly diverse community, I know the benefits are immeasurable when our differences are truly embraced. Yet at this time, our diversity is being challenged to the very core. The latest Mapping Social Cohesion report found that following a polarising referendum debate and amid rising community tensions over the war in Gaza, social cohesion in Australia is at its lowest level in 16 years. The report indicates that significant numbers of people experience prejudice and discrimination routinely in everyday life, and that attitudes to governments and democracy in this country are now politically charged and polarised. In this context, then, why are we seeking to establish yet another separate standard of treatment for those looking to us for protection and a better life in this country through this legislation? We cannot continue on this trajectory. We need to come back to our values as a nation, back to community, back to embracing diversity and back to basic human rights. The same standards must apply to all, which means all people must be treated fairly and not discriminated against because of their race, colour, gender, language, religion, political beliefs, status or any other unlawful reason. Citizens or non-citizens, everyone deserves to be treated with dignity and respect for their basic human rights, and we must ensure this core belief is upheld in this new legislation. For the power of human rights is in its universality. Every human being is born equal and deserving of justice and equality before the law. A right enshrined in the International Covenant on Civil and Political Rights is essential for fair decision-making. We have an opportunity to do good here, to begin to redeem our international reputation, and I encourage all of us in this place to see that opportunity for what it is and embrace it. The removal of carve-outs for migrants and refugee applicants would ensure equality before the law, providing full, fair and equal protection for all. And I look forward to moving my second reading amendment when the time is appropriate. Thank you.